Note: Defendant is denied effective assistance of counsel in violation of the Sixth Amendment. Right due to counsel did not follow the due process of the law and did not advise the Honorable Court of all the facts of the case, and the relevant and controlling laws in spite of full cooperation and assistance of the defendant by emails supported by facts and exhibits more than what is attached in this motion. The appointed counsel got the facts, laws, and case laws by emails, and the counsel even acknowledged the assistances of the defendant by an email by stating, "I appreciate your continued cooperation," to defendant, and for not filing the statutory motions outlined in this motion, and the contents of this filed motion is the clear proof of what the counsel was required by the law to do, but it failed. The assistance of the appointed counsel in this case did not even come close to the standards set by Strickland v. Washington, 1984, 466 U.S. ATL ed. 2D 674, 104 S. Court 2052, which is adopted by the Supreme Court of Illinois. Illinois Supreme Court in People v. Albanese 104 Ill. 2D 504, 524-25, 473 NE 2D 1246, 1984, states. Defendant further argues that he was denied effective assistance of counsel in violation of the Sixth Amendment due to certain acts or omissions of counsel. He urges that each of these alleged errors was of such magnitude as to satisfy both the standard this court has used to evaluate alleged deficiencies in representation, People v. Beer, 1980, 79 Ill. 2D 103, 120-21, actual incompetence of counsel entitles defendant to a new trial if the incompetence created such substantial prejudice that the trial result probably would have been different, and the standard enunciated in United States ex rel. Williams v. Comey, 7th Circle 1975, 510 F2D 634, 641, Sixth Amendment entitles defendants to representation that meets minimum standards of professional representation, upon which he relies. The Supreme Court, in Strickland v. Washington, 1984, 466 U.S. ATL ed. 2D 674, 104 S. Court 2052, recently adopted a standard which appears to combine elements of both Greer and Twomey. The court held that the constitutionally guaranteed assistance of counsel has not been provided if the defendant can prove that counsel's representation fell below an objective standard of reasonableness and that counsel's shortcomings were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. 466 U.S. ATL ed. 2D 674, 693, 104 S. Court, 2052-2064. Emphasizing that the defendant must prove prejudice, the court stated, the benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. 466 U.S. ATL ed. 2D 674, 692-93, 104 S. Court, 2052-2064. The court also directed that the performance inquiry must be whether counsel's assistance was reasonable considering all the circumstances. 466 U.S. ATL ed. 2D 674, 694, 104 S. Court, 2052-2065. Emphasis added. 2. Furthermore, and because of the ineffective assistance of counsel, defendant has the right under the Constitution to file this motion as follows. See Adams v. United States ex rel. McCann, 317 U.S. 269, 279. The right to assistance of counsel and the correlative right to dispense with a lawyer's help, emphasis added, and Snyder v. Massachusetts, 291 U.S. 97, 106, 1934. Again, defense may be made easier if the accused is permitted to be present at the examination of jurors or the summing up of counsel, for it will be in his power, if present, to give advice, a suggestion, or even to supersede his lawyers altogether and conduct the trial himself. See Lewis v. United States, 146 U.S. 370, a prosecution in the federal courts. Emphasis added. United States of America, State of Illinois, County of DuPage. In the Circuit Court of the 18th Judicial Circuit. People of the State of Illinois. Versus case number 2016-CM1620. Muhammad Noah, defendant. Notice of motion. 2. DuPage State's Attorney. Judicial Office Facility, Annex 503N. County Farm Road, Wheaton, IL 60187. You are hereby notified that on the 14th day of March 2017, at 9 a.m. or at soon thereafter, as defendant may be heard, I shall appear before the Honorable Judge James D. Oral in courtroom 4005 or any other judges may be holding court in his absence in the courtroom usually occupied by him in the DuPage County Courthouse, 505N. County Farm Road, Wheaton, Illinois 60187, and then and there present the attached defendant's motion to dismiss pursuant to 725 ILCS 5-114-1, 86, and 725 ILCS 5-114-1, 88, a copy of which is attached hereto, and request a hearing instanter, at which time and place you may appear, if you so desire. Signed by Muhammad Noah, defendant. Muhammad Noah, defendant. 536 Creekwood Court. Apt. Hash B. Westmont, Illinois. 60,559. Proof of service by email. On March 14, 2017, I, the undersigned, on oath certify and state that I served this notice and motion by email, a copy to the DuPage County State's Attorneys at sao@dupageco.org. Signed by Muhammad Noah. United States of America, State of Illinois, County of DuPage. In the Circuit Court of the 18th Judicial Circuit. People of the State of Illinois. VS case number 2016-CM1620. Muhammad Noah, defendant. Defendant's motion to dismiss pursuant to 725 ILCS 5-114-1, 86, and 725 ILCS 5/114-1, A8. In order for the Honourable Court to be fully advised in the premises, now comes the defendant, Mohammed Noah, please see endnote, and moves this Honourable Court to dismiss this matter with prejudice. This